Welcome all to another edition of SLW's IP Summit Series. I'm David Buck, and I wanted to introduce Judge Michael Kim, who would be talking to us today about some USPTO updates and other USPTO programs that are useful during COVID-19. I'd like to thank our sponsor today, MIPLA, Minnesota Intellectual Property Law Association, who has agreed to co-sponsor this event along with Schwegman, Lundberg, and Wissner. You can advance the slide. And I just wanted to point out that we are at the summit of the summit here because we're at Machu Picchu. So it's only downhill from here. And just a couple of quick housekeeping notes here. Reminder that today's presentation will be recorded and that the slides and a link to the recording will be available to registrants. And we encourage questions via the Q&A tab on Zoom. And we encourage people to follow us on LinkedIn, including and through the website slw.com, and also to check out MIPLA as well. They have some great content available as well. And today's speaker, as I said, I'm David Buck. And today joining me is Acting Vice Chief Administrative Patent Judge Michael Kim of the Patent Trial and Appeal Board. You can advance the slide. Judge Kim was appointed to PTAB in April of 2011, and he's been acting as a Vice Chief Judge since November of 2019. And he's been a lead judge since 2013. Judge Kim has several management responsibilities within the PTAB, including coordinating policy regarding subject matter eligibility, and also he runs the Judicial Law Clerk program. Judge Kim has a wealth of experience under the AIA, including conducting inter partes reviews and post-grant reviews. He's also has a lot of ex parte experience reviewing decisions of examiners. Judge Kim has a mechanical background, but he also works extensively with business methods and electrical technology areas. And prior to joining the PTAB, Judge Kim was a patent attorney at Finnegan, so he knows what it's like to be in other shoes. So go ahead and advance the slide. And myself, I'm a senior attorney with Schwegman, Lundberg, and Wissner. I've been with the firm for 7 years. I've actually been a patent attorney since 2007 with a couple of different law firms. So I do have quite a background of various areas that I practice in terms of technologies and experience. You can advance the slide. So just as a brief episode overview here, Judge Kim will, as I said, update us on some changes within the USPTO, including PTAB updates of recent precedential cases and practice changes. And time permitting, we'll cover some helpful USPTO programs that might be helpful to an applicant during the pandemic. Go ahead and advance. And with that, I'll turn it over to Judge Kim.
Well, thank you, Mr. Buck, and thank you very much to our sponsors for this opportunity to engage your community. It's interesting, you know, with the pandemic, in one sense, I feel like events like these would have been in person, which would be kind of fun. I've personally only been to Minnesota once, but actually my wife did go to law school there, so that's something that I certainly wanted to do to sort of, you know, see her old stomping grounds. So, you know, maybe when this is all over, that's something that we can revisit. I believe the PTAB has visited the Minneapolis area twice, once in a Midwest tour about AI trials back in, I believe, 2014. And then I believe we also did a joint PTAB TTAB stadium tour in conjunction with the University of Minnesota Law School. So we're quite familiar with the area. I say ironically though, because I think also the pandemic has also made it more accessible in that, because we're all appearing virtually, more of these seminars, it seems to me anyway, more of these seminars seem to be popping up all over the radar. So I guess in that sense, it's good. So who knows? So thank you again. And yeah, these are generally the 3 topic areas that I'm going to talk about today. I guess for what I'll probably do is just go through each area, and then I'll stop. And there's a question and answer function, I believe, on the Zoom chat. So put those in, and I'll see what I can do. So with that, if we could advance to the next slide, please. Okay, so the first thing I was asked to talk about were some precedential opinions, and certainly for those of you who follow PTAB practice, these are some of the more recent and bigger ones that are out there. I'm actually going to tackle the one at the top, Applefintiv, last. That is certainly a precedential case that was relatively recently designated, but there were also 2 informative decisions which were designated later that sort of add color to it. And it seems to me that there's been a lot of interest in those cases in the community, so I'll save that for last for now. So the next 2 cases, Hulu and Hunting Titan. So these are both precedential opinion panel cases. So our current iteration of SOP1, which is our standard operating procedure 2, sets forth a precedential opinion panel. And the precedential opinion panel, for those who don't know, is the default members are the director of the USPTO, the commissioner for patents, and the chief judge of the Patent Trial and Appeal Board. And their role really is not to sort of go into the nitty-gritty on every single case and decide particular cases. They're really looking to decide issues of exceptional importance. So ones that really touch on policy matters, perhaps some inconsistencies in the law. There's a bunch of ways you could go, and the office needs to pick one. And so that is a vehicle that is used to sort of put us, PTAB, as well as the agency, on sort of a consistent path. So there have been 4 to date, and Hulu and Hunting Titan are 2 of them. So I'll start with Hulu. So Hulu was a case that was issued last year, and that involved printed publications. So there's been this issue that's been coming up, recurring in trials of sort of, okay, patents aside, printed publications, like what do the parties, and particularly what does petitioner need to show in the petition on institution in order to sort of get a better way to put it, I guess a presumption, if you will, that something was a printed publication. And this primarily comes up in the context of NPLs, so non-patent literature. And in this particular case, there was sort of a textbook involved. So, what do the petitioners sort of point to? Generally, they pointed to the copyright, the fact that, it's a book, it looks like a textbook. And then patent owner came back and basically said, no, great, it has a copyright and it's a textbook. We don't really know anything else about it because the touchstone of whether something can be used as a printed publication in any proceedings, but our proceedings as well, is public accessibility. So those facts by themselves don't really tell you anything about public accessibility. Now there's a whole range of spectrum of evidence that was submitted. Some petitioners would just submit the book, others would submit the book, and then like a researcher who went to 8 libraries and found the book through card catalogs. And so, but there was a lot of uncertainty as to where sort of the line was drawn, particularly on institution for trial. So Hulu sort of put some meat on the bones there. In this particular case, they didn't really set forth any particular definitive standard per se. That's really guided by Federal Circuit case law. But at least for institution purposes, it said, okay, in order to have a trial, we just need like, when you put a bunch of factors together, is it kind of like, is this something that on its face sort of would have been publicly available? And so again, what the petitioners pointed to were panel pointed to were the copyright and the fact that, it's from a well-known publisher. And so, did the likelihood of, patent owners or petitioner sort of conjuring this textbook out of nowhere seems pretty low. So it's worth having a trial. Now, and during the trial, both parties could submit evidence that, this book either existed or didn't exist, or could also be publicly accessible. So with that, in this particular case, the original panel had said that petitioner had not met its burden on institution of proving that this was a printed publication. The POP panel reversed that panel, and so then went to trial to figure out sort of the boundaries of that. In the trial itself, the case was remanded back to the original panel. Okay, so that's Hulu. Hunting Titan is our most recent one. So this was issued on July 6th, so right after the 4th of July weekend. And in this particular case, it dealt with motions to amend. So the specific facts that are relevant to this case was petitioner filed a petition, patent owner filed a response, and it went to trial. And during the trial, patent owner filed a motion to amend. So petitioner came back, and when they came back with an obviousness ground. Now, in final written decision, the panel found that the substitute claims in the motion to amend were unpatentable, but they didn't find it under obviousness, they found it under anticipation. So the two broad questions that were in the POP request for Hunting Titan were, one, should the parties, particularly patent owner, been given notice of this so they could respond? And second, what is the board's role in stepping in these contested proceedings as to figuring out patentability? And the long and short of it is in this particular case, the presidential opinion panel decided that, one, yes, if the board eventually wanted to do an anticipation ground, that's something that should have been brought forward so that patent owner had a chance to respond. But also that in this particular, we really, the office as a policy matter wants to leave sort of the battle over, both the petition, but also the motion to amend, really to the adversarial process. And so certainly there are circumstances perhaps where the board would come up with its own ground of patentability, but that, for better or for worse, those circumstances are going to be extremely rare, and that we're really going to rely on the parties to let the adversarial process play out. They both have a vested interest in this, and so to really trust the parties to bring up all the relevant issues that are going to be in the case. And so we at the board will, decide those issues, certainly. But as far as injecting ourselves in the process, that's really going to be limited to certain rare situations. Okay, so those are the two presidential opinion panel cases. Advanced Bionics. So Advanced Bionics is not a presidential opinion panel case. However, it was a case that was made precedential by designation by the director in consultation with the board under SOP2. And Advanced Bionics goes to 325D. So as far as institution goes for IPRs, we'll just stick to IPRs for now. There are really two statutes that are in place. So one is 314A. So 314A says that if a certain threshold is met, reasonable likelihood, that the office may, the director actually, may institute a trial in that proceeding. So may makes it discretionary, and then further informing that discretion is 325D. So what 325D says is we're basically going to take into consideration things that already been presented to the office. And so the high level policy involved there is, look, if the office sort of looked at something once, we're not saying that you shouldn't look at it again, but you should take into account the fact that they looked at it once. So, what would be a typical situation? So what a typical situation would be, let's say hypothetically, there was a claim, it was examined, and there was a piece of prior art that was cited against it. And, a lot of prosecution went back and forth. And at the end of the day, the examiner was satisfied, either through amendment or through argument, that that claim was patentable over that piece of prior art. So what advanced Bionics says with a two-part framework is we're going to consider when petitioner files a petition, and let's say they want to rely on that same art that the patent owner overcame, we're going to ask based on 323 for a little bit more. So the two questions that are asked, and these are rooted in statute, is one, does the petition present the same or substantially the same prior art presented to the office? And certainly something that was cited by the examiner during prosecution, extensively discussed, that certainly qualifies. And then if that is the case, whether petitioner has shown that the examiner materially erred. So the thinking here is, especially with 103, there's a lot of areas of technical, I want to say, discretion or understanding. And so the examiner, for better or for worse, made a call that a claim was patentable over a certain piece of prior art. So it said, okay, petitioner, so we have this examiner weighing in on this. What did the examiner do wrong, essentially? What did the examiner miss? And so that's really the separated inquiry, is how well the petitioner sort of explains what went wrong in that situation. And then based on that, the board will sort of decide whether, that holds water or not at the end of the day. This doctrine has been around for a while, since 325D, the original statutes for the AIA. There are a couple of cases. There was an informed decision, Becton Dickinson, that put out 6 factors regarding that. And advanced Bionics is really building on those 6 factors. It basically takes those 6 factors and sort of really plugs them into a 2-part framework. So that's advanced Bionics. And I'll stop for questions before I go to the Applefintiv case. Okay, so hearing none. As far as precedential changes go, I'm sorry, if you go back to the previous slide. Thank you. So Applefintiv is actually an order, and what that order does, it discusses 6 factors that the board will consider in determining whether to institute discretion in view of a related district court proceeding. And the overall policy gloss on this is, so, we are an alternative to district court litigation. However, in certain situations, the district court, it's about an investment of resources. So if the district court, for example, has invested a lot of resources in a case, and for example, they're going to finish a case a lot faster than the board, then maybe it doesn't make sense for the board to step in that situation and sort of decide the issues. There's a resource component to it. There's also an inconsistency component to it. So hypothetically, if the district court finishes first, hypothetically, if the same parties come to PTAB on the same art and the same issues, and an inconsistent result occurs, that's not really good for the system overall. So it really puts those 6 factors, sort of flesh that all out. And the reason, really, though, they're kind of considered together, and they're really kind of considered together because, so you're maybe thinking, well, let's say the trial's later and the PTAB goes first. I mean, isn't there a possibility that it could be inconsistent there too? That is certainly possible. So one of the things that the 6 factors really trying to tease out is the likelihood of a stay. So district courts obviously have full autonomy, district court judges full autonomy over their dockets and how they run their cases. And stay is certainly one of the components that they can, do. Now, we obviously have no say in that whatsoever, but in as much as, we take on a case earlier in the process and perhaps save the parties and the district court resources, claim construction, discovery, those things, the district court doesn't have to, but may determine that if a petition is filed or if a trial is instituted, that it's better for the system if the district court case is stayed and to let PTAB do its job, especially for situations where we're really deciding the same issues. So that order was put out, and then we got feedback from stakeholders that, well, that's nice, how do these play out in real life? So for that, I'm actually going to go to 2 informative cases, which are not listed, but They were, if you go to our, by the way, all our informative precedential decisions on our website, just go PTAB, informative precedential decisions in your favorite search engine. It'll take you right to that page. And these are two of the latest decisions that were designated. So one is another Applefintiv. So in that case, so the first Applefintiv case, which is precedential, was an order. This one actually is a decision on institution, and it denies institution because it applies the factors in the order, and it basically determines that, you know what, it's not really worth the board's time to invest resources in that particular case. So that's sort of like one end of the bookend. The other one, decision that was designated informative, was Sand Revolution versus Continental Intermodal Group. So that one goes the other way. So that one, it's actually a decision on request for rehearing, and that applies the fintech factors. And there, what they basically said was, if you apply all the fintech factors, two of the factors that sort of play out and sort of informed the way the panel went in decision was, one, there's kind of uncertainty of trial date. So if there's uncertainty to trial date, we don't know if we're gonna, who's gonna finish first in that situation. And so maybe it's okay for PTAB to go on. And the other one was that the petitioner in that case actually stipulated, for example, not to raise in the district court the same patentability grounds raised in the IPR. So even if hypothetically both trials went forward, they're not gonna be on the same facts. And so even if it's inconsistent, it's totally possible that under one set of facts in our patent, it's found valid, but in the other one, it's found invalid. So again, I guess in a broad sense, maybe it's inconsistent, but in sort of a fact-specific sense, it really is not. So those are those cases. Does anyone have, I'll stop again to see if anyone has any questions. Okay. So if we go to the next slide, please. All right, so I'm now gonna go over remote hearing practices. And these are practices that we have been doing since we went on mandatory telework, which was March 13th, and continue to be doing. And we know, so in a way, remote hearings, or in what I mean by remote hearings, is a party appearing remotely. It's been done for a while, especially in ex parte appeals. We've long provided parties the option to either appear telephonically or by video. We know sometimes ex parte appeal hearings are in general like 20 minutes, and so sometimes it may not make sense to travel across the country if you're coming to Alexandria for a 20-minute hearing. So that was an option that's provided, but we understood some people prefer the in-person. Current situation, definitely not possible. And so what I'm gonna go over, is just an overview of sort of how this all works now, given everything, and some tips and advice, some best practices. So just in general, high level, all oral hearings for appeals are currently telephonic, and oral hearings by AI trials are primarily by video, but also some of them by telephone. How will you know? I know, so there's a lot of logistics involved. You will receive a hearing order with the instructions. For appeals, you're gonna receive it a few days before the oral hearing date, and for AI trials, you're gonna receive it about 3 weeks before the oral hearing date, which provides more detailed instructions. General rule, if you have any questions or special requests, please contact us. The email is ptabhearings@uspto.gov. Okay, so appeals, what is it gonna look like? So it's gonna give you a date and time, and they're going to tell you that we're gonna provide you connection information, dial-in information in this case, a few days before. The one thing to note about ex parte appeals is we do them in blocks of 6. So let's say you get a schedule for whatever, August 4th at 1 p.m. You may be at 1 p.m. You also may be at, you can do the math, 1:20, 1:40, 2 o'clock. So there is sort of that uncertainty there. If, in general, we just ask you to be available roughly during that time slot. If you need more precise timing, that's fine. We understand, and you can go ahead and contact us, and we'll try to get you that information. For trials, it's a little bit different. So because most of them do require video setup information, we ask that you contact our hearing staff 5 days before. And then a day or two before the oral hearing, we are actually going to call you. So members of our video teleconferencing operations, people will call you. We're going to do everything. We're going to test your connection. We're going to make sure that your cameras work and we can hear you, and really resolve any technical issues you have at the time, so that when you go to the hearing itself, you don't really have to concentrate on the technical aspects. That'll all be taken care of. So what are some best practices? So the number one thing is, look, we know things happen. So if at any time during the proceeding, you got any technical difficulties and it really fundamentally undermines your ability to represent your client, please let the panel know immediately. Please let them, if you're still on the line, say it verbally. If you're disconnected, send an email to PTAB hearings, and we'll make sure that we take care of it as soon as possible. Some other best practices, we found that it's helpful that if you unmute yourself only when speaking. We all probably had it where there's just inadvertent background noise, and this is just a way to make sure that those sort of distractions don't happen. Each time you speak, we ask you to identify yourself. It really helps a lot of people. It also helps a court reporter to make sure that whatever is attributed to whoever person gets put in the right place. There may be an audio lag, so we generally recommend, observing a slight pause before speaking. Hopefully over video, that's not as hard to do, but certainly over telephonic, we understand. And for best audio quality, and I'll admit I'm not doing this right now, we recommend using a headset and a microphone. It just make things clearer and crisper. Other best practices for video, just dress like you would for any other in-person hearing. We take it as seriously as we would as an in-person hearing, so there's no really deviation from there. And one thing, for better or for worse, we're not having any shared screens right now. So we have access to all the papers. We have access to your demonstratives. So what we ask is, if you're referring to a demonstrative, that's great. Just please refer to whatever slide or whatever exhibit by slide or page number. And I assure you, we're all very adept at PDFs. We can find it. And we also find that it's the best practice because, when we go back and review the transcript later, sometimes there'll be, discussion about something, and to have some context because, we're talking about slide 20. That's usually pretty helpful to us as a best practice. We also are currently allowing public remote access to our hearings. So for there, if you go to our PTAB hearings webpage under hearing schedule, you can just sort of get the instructions for that. Resource permitting, we generally expect to grant those requests. The one real time that you may be denied is confidential information as well. So sorry, in those situations, we are going to just limit it to the parties and the board. And it's audio only. There's no video, and the public is muted in those situations. So I think that's really it for remote hearings. I'll again stop to see if anyone has any questions. Okay, hearing none, I'll tell you about one of our newest programs. If you go to the next slide, please. All right, so this is about our fast track appeals and all the information. Anything I say, if you want more information on it, there is the website right there. It has everything. It has forms, which I'll go over a little bit in a second. It has FAQs, and again, if you have any questions as you're going through this process, we have a mailbox there. Please go ahead and send it to the mailbox. We'll do the best we can to both get back to you as soon as possible, as well as put in our FAQs if it's a question that we get from a lot of people. So general overview, it is a one-year pilot program that started on July 2nd. It does have a fee. It's a $400 fee because technically the way it's requested is a petition to the chief judge, and that is the cost for that. Our goal is to get you a decision within 6 months of the time the petition is granted. Because it is a pilot program and we're not exactly sure how it's going to work out, right now we have limits. So there is a 500 total petition grant limit for the year starting July 2nd. And furthermore, each quarter we're limiting it to 125 granted petitions per quarter. Hearings are permitted with some restrictions, which I will go over later. Okay, so what the program isn't. The program does not impact any procedures before the docking notice is issued. So most pertinently, it doesn't really change anything about the briefing before the examiner. So technically, jurisdiction to the board doesn't pass until all briefing is completed, because for those of you who do appeals, you know, first step, well, there's a lot of steps, but a main step is appeal brief, and then examiner's answer. So that comes the examiner, the board's not involved, and then a reply brief. So it's only at that point that it goes to the board. So it doesn't change any of those practices. So what appeals qualify? The short answer is pretty much anything. The one thing we ask is that to make sure that a docketing notice is issued. So again, we can't really take jurisdiction until the jurisdiction is transferred to the board. So pretty much as soon as like the reply brief happens, patent sends the case off to us, and we issue a docketing notice, you know, pretty soon after that. And two points to be clear: it's not limited to quote unquote new appeals. So it's not limited to appeals that are after July 2nd. It's any appeal where a docketing notice is issued that can be part of the program. The other thing though is we don't allow petitions for anything that's already treated special. So anything that's, you know, for example, petition to make special because of age or any other ones, those are already on sort of an accelerated track, even through the board. And so we're not gonna like super duper accelerate it, if you will. And also similar to re-exams and reissues, those are already handled with special dispatch. And so those are not eligible. And all the categories are listed if you go into the MPP, section 708.01, they're in there. So requirements. So what are the requirements? We try to make it pretty simple. We need the application and the appeal numbers. And so this is why the docketing notice is important, because you don't get the appeal number until you get the docketing notice. It just certifies that the appeal qualifies. You know, again, it's pending appeal. There's nothing about it that's treated special. And it needs to be accompanied by the $400 fee, as noted. The one thing we will say is that fee is non-refundable even if the petition is denied. So that's why we want you to make sure. We certainly don't want you to inadvertently waste money. So please, before you file one of these, go to the website, look up all the requirements. If you have any questions, you know, let us know. How you can submit it? Pretty much anyway. You can do EFS Web, Patent Center, you know, Postal Service. Like the office generally, electronic submission is preferred. If you go to our website, we actually have a form, PTO/SB/451. That's like the simplest way, and so that's why I recommend it. It's not required, as long as you have sort of the basic information that we noted. You know, we'll sort of treat a petition as a petition if it looks like a petition, and then the petitioner will be notified if it's granted or denied. You know, and again, you know, you can petition again if it's originally denied, but unfortunately, you're not going to get the filing date of the original petition. So if there's two petitions in the case, each one's going to be sort of treated on its own. Like I said, all this information, including the petition form, is on a fast track appeals page. And I see we have a question. So for fast track appeals, it asks, is it limited to 100 or 125 per quarter, given total of 500 noted? So it's 125 per quarter, and the way we measure a quarter is a 3-month period. It actually ends up lining up okay. So July 2nd, 3 months from July 2nd is October 2nd. So there's your sort of 3-month period. And the way we counted it is the day that the Federal Register notice was published. Now we do note that if you read the notice a little bit more carefully, you know, let's say you're like the 126th petition in a quarter, maybe there's no others in a quarter, there's a possibility, you know, that we may, you know, consider that one, or we may hold it in advance until the following quarter. It really depends on sort of our internal workload issues. So that's why we have to be a little cagey. on that one. Why have limits at all? We have other goals. So for example, we want all appeals to sort of be decided in a timely manner. Our goal is 12 months. And right now we're, knock on wood, well on our way to meeting that, hopefully soon. Can't really promise anything. We don't exactly know what the future holds. And so, we wanted to provide those limits, certainly to provide robust participation, but it doesn't compromise with other goals, like, for example, overall pendency. And so I know you're asking, okay, like, I don't want to be the 126th petition. How do I know? We have that on our website as well. So right now we're updating it roughly on a weekly basis. We hope that it's, as we get closer to 125 per quarter, that it's more frequent than that. So certainly whenever you're deciding to file a petition, I would personally recommend right up to the date you're probably going to file it. I would go on the website and see how many there are that have been filed so far per quarter, so that you can make your appropriate calculations accordingly. If you go to the website today, it's kind of proceeding roughly at like a little over 1 a day rate. So I don't know if that means, it could mean a lot of things. I mean, maybe there was some pent-up demand and it's going to slow down, or maybe people are just finding about it, so it'll speed up. Who knows? But that just seems to be the rate that we're going at right now. Hearings. So as I said before, any appeal qualifies with the one noted exception with special appeals, and heard cases are included there. So heard cases can be fast-tracked. Now the hearing requests, can include a time and location preference, and we will do our best to accommodate you. However, just so everyone's aware, can't guarantee any particular hearing room, office location. If you do by video or telephone, that probably makes it more likely that we can grant whatever request that you have. But let's say you want to do in person and we give you a location and it just doesn't work for whatever reason. That's fine. We understand that happens. And so one of the options we give, certainly for the first time there's a notice regarding in-person hearing at a location, to reschedule the hearing. You still have the option to reschedule the hearing. However, unfortunately, you can't really stay in the pilot program at that point. So you have a couple options. At that point, you can say, okay, I really want it in person, but I'd really rather have the fast track. So you can opt out of the fast track. You can request the video or telephone. You're like, I really wanted the office, but video, telephone is fine, given everything. And again, right now the default for all appeals are fast track. So that's really all I have as far as fast track and everything else, really. So unless there are other questions, I'll hand it over to Mr. Buck.
Thanks, Judge Kim. You can advance the slide. Thanks. Yeah, so the other part that we wanted to highlight during this program was just some useful PTAB programs for applicants. And they're useful in the sense that they can save money in most cases if used properly in terms of advancing prosecution. And they can also, shift some time periods when you pay certain fees. You can advance the slide. Yeah, so the programs I wanted to highlight are the full first action interview pilot program, or the request for deferral of examination, and the COVID-19 prioritized examination pilot program. And these are just some of the programs the PTO has. I know there's many other, especially pilot programs available to the applicant that can be useful and very good for the applicant in terms of advancing prosecution. You can advance the slide. Yeah, so the full first action interview pilot program, an overview of this is upon a request by the applicant prior to the first office action on the merits, the examiner will conduct a search and provide the applicant with a condensed pre-interview communication. And this will basically cite any kind of relevant prior art that the examiner has identified. It may identify some proposed rejections or objections that the examiner intends to make. And within 30 days of that receipt of that communication, the applicant will schedule an interview, and there's no requirement, but the applicant can submit amendments and arguments to be discussed during that interview. And at the interview, the intent is to have the relevant prior art discussed, and any proposed amendments or arguments can also be discussed at that time. And if the agreement is not reached, then there'll be just a first action on the merits. Usually this will repeat kind of the content of the communication and build out from there. You can advance the slide. So all utility applications in all technology areas are eligible for the pilot program. However, there's a catch. You can advance the slide. The application must have 3 or fewer independent claims and 20 or fewer total claims. It must not contain any multiple dependent claims. And then probably the key provision is it must claim only a single invention. You can advance the slides. So what we see a lot sometimes is the application may not be eligible from a restriction standpoint, and you'll be issued just a first action on the merits, office action on the merits. But kind of how the program works is the examiner will follow restriction policy and practice and conduct a prior art search. We'll kind of follow existing policy and practice in determining eligibility of the subject matter. And then it will issue that communication I was talking about that gives you a 30-day response period to accept or decline the interview. I know it seems like you can extend the period in which you can conduct the interview for an additional month, 30 days. I've personally not taken advantage of that. You can advance the slide. So continuing how it works, the applicant can choose not to interview if they so choose. If they do choose, you conduct the interview in kind of a typical manner where the applicant is required to document the interview. The examiner is also required to document the interview, and it's encouraged that you submit proposed amendments and remarks for the record. You can advance the slide. So there's a form that you must file to request this pilot program, but you must file it at least 1 day prior to the first office action on the merits in the case. Go ahead and advance the slide, please. So the purpose of the pilot, I guess there's kind of a fourfold purpose that the USPTO has identified. One is to promote personal interviews prior to issuance of the first office action on the merits. The bullet points 2 and 3 are kind of tied together. One is two is to advance examination of the applications once taken up, and facilitate resolution of issues for timely disposition of the application, and then also to give applicants more options in regards to the amount of notice and procedure needed. You can advance the slide. So breaking down the first objective, which is to promote personal interviews, it really allows the applicant to kind of develop a rapport with the examiner, and the examiner to kind of develop that rapport with the applicant to kind of have your case stand out a little bit maybe from some other cases. I would note there is kind of the drawback that some examiners don't like to do interviews. I personally know several that I've worked with in the past that I have kind of flagged as examiners that just don't like the interview process, and I would encourage those before making the request to maybe do some due diligence on the examiner to see, you know, if it's worth having an interview in the case. You can advance the slide. So this is the idea here of advanced examination of applications once taken in turn is really kind of the heart of where you could potentially get some reasonable compact prosecution. So we all recognize that examiners have a limited time to review our applications, and sometimes understanding what the invention is can turn on how a term is used in the application or specification, or in the mechanical arts it might turn on a figure or something that's could be hard to identify to a reader with limited time on their hands. So I think the real thing that can be done with these first action interviews is kind of just clarify any questions that might arise regarding the specification. You can correct any potential misunderstandings that the examiner might have of kind of what the invention is. And it really allows you to advocate, to set the stage for your position in kind of a more informal manner with the examiner. You can advance the slide, please. And as I said, bullet point 3 was kind of tied closely to bullet point 2 to facilitate resolution of issues in a timely manner. So I think that I identified another thing would just be allow as the examiner and then to raise issues under, initial inquiry type issues, which I would say would be subject matter eligibility and enablement and things like that at the initial stages, and also lets you to respond to them as an applicant. You can advance the slide. So the fourth objective, and this is one that can save you some money potentially in the long run, would be it really gives the applicant more options regarding notice and procedure. And it really allows you to develop kind of a feel for the case, just to understand kind of what the examiner's potential positions might be. It really allows you the chance to kind of, either abandon the case or refocus the case should you feel that would be kind of your best path forward here. You can advance the slide. So further information on this pilot program is pretty extensive, and it's available through the USPTO site that's provided here. And they also have a very helpful PowerPoint slide that's available through that website as well. You can advance the slide. So deferred examination, this isn't a pilot program, but it is available to applicants. Basically, it's available if you follow a certain form, and you, of course, have to pay a fee. But it allows you to defer planner utility application prosecution for up to 3 years, although you can specify a lesser period of time should you want that. Go ahead and advance the slide. So as I said, you file the form, and then you pay a fee for requesting a deferral of examination. If you had made a non-publication request, you must rescind that. I would note that, once the application is published, a third party can trigger examination of the application. Go ahead and advance the slide, please. So basically, this is a good program if you want to defer search and examination fees. It allows you, the flexibility and potential cost savings if the case is later abandoned. I think it's good in the sense that maybe you're not, as I said, flying blind here. You might have maybe an ISR from a PCT application that's favorable, that you are kind of keeping in your back pocket, or potentially you're letting some prosecution play out in maybe another jurisdiction, and with the idea of potentially using patent prosecution highway or another helpful program that you can then utilize with within the USPTO. Please advance the slide. So I linked to some further helpful resources here, including the form that you would require, but also some kind of discussion on the deferral of examination. Go ahead and advance the slide. So the final program I just kind of wanted to highlight was the COVID-19 Prioritized Examination Pilot Program. And it basically allows prioritized examination of up to 500 qualifying patent applications. And basically the fees for a prioritized examination are waived. And under the pilot, the USPTO will kind of advance prosecution in that prioritized manner. You can advance the slide. So there are eligibility requirements. You have to have a product or a process that's related to COVID-19. The product or process must be subject to an applicable FDA approval for COVID use, although I believe they are providing waivers and things for that at this time. And you must be a smaller or micro entity to apply for the program. You want to advance the slide, please. So eligibility for the pilot, as I said, you must request to be part of the pilot. You can be either for non-continuing, original, non-provisional utility or plant applications, but it's also available if you had filed a request for continued examination. So it doesn't have to be at the time prior to filing or the examiner picking up the case. Please advance the slide. So you also must meet requirements for kind of a prioritized track 1 application. So that means you can have no more than 4 independent claims and 30 claims total. You must not have any multiple dependent claims, and you must pay the required fees. Go ahead, advance the slide, please. And the request is available. There's a link to the form that I linked here. So please advance the slide. And I think that's it, unless anyone has questions. Again, would like to thank Judge Kim for joining us today and for MIPLA for sponsoring. It looks like